Thank you very much. President, Chair, Excellencies, honorable participants, it is a pleasure to be here for my third interactive dialogue with you as Special Rapporteur on the independence of judges and lawyers. I begin with my official country visit to Chile in July and August of last year. I commend Chile's achievements in building a justice system recognized for its strong institutions. Judges and prosecutors enjoy commendable independence in their everyday work. However, many Chileans still believe there are two kinds of justice in Chile, one for the rich and one for the poor. Chile has the means to address this and the public will to do so. I was impressed by the professionalism of the Defensoría Penal Pública and urged the government to grant it full autonomy. I also commend the Judicial Academy and innovative institutions such as the environmental tribunals. Chile's efforts to modernize criminal justice are also notable. I encourage similar reforms to its civil procedure code. I welcome the progress toward creating the National Access to Justice Service, which is now under Senate review. This initiative could play an important role in overcoming deep structural barriers and inadequacies in civil legal aid. During my visit, I heard frequent concerns over influence peddling in apex court appointments. I strongly recommend that Chile integrate the high system of public administration in preparing candidate lists and adopt a merit-based judicial appointment system with clear, objective, and transparent criteria concerning ability, training, and integrity. This will help restore public confidence. I highlight the need to separate the administrative and jurisdictional functions of the Supreme Court. I also urge the abolition of the figure of the abogado integrante, practicing lawyers who are placed on a list temporarily and invited to complete quorums. As Chile responds to increasing organized crime, I warn against punitive approaches that undermine human rights. I'm concerned that the 2025 budget reduced judicial funding. Rural judges, in particular, need greater support. I was concerned to hear that prosecutors and judges investigating grave human rights violations faced harassment through social media, including from elected officials or political party representatives. The legal profession requires stronger regulation, ethics training, and accountability mechanisms. In particular, I recommend adopting a binding ethical framework for all practicing lawyers. I further call for an end to the prolonged state of exception in the Araucanía and Biobío regions and urge Chile to formally recognize the land rights of indigenous peoples in the Constitution. I hope the report of the Commission of Peace and Understanding will provide a good basis to move forward. Many grave human rights cases from the Pinochet era involving torture, summary executions, and enforced disappearance remain pending. Victims still await reparation, families still search for their loved ones, and society awaits the truth. I note that in my report, I've made some recommendations about access to justice, especially for migrants and indigenous peoples. In closing, I call on Chile to take bold steps to address the long-standing structural issues in the justice system. Meaningful reform will ensure trust and support from the Chilean people, who see the system as worthy but flawed. President, Chairs, Excellencies, honorable participants, my thematic report is entitled The Right of Indigenous Peoples to Maintain and Develop Justice Systems. I want to thank Aloysia Soné, Caterina Sadao, and Indigenous Peoples Rights International for their assistance in preparing the report. For countless generations, Indigenous peoples have repaired harm and ensured and maintained balance within communities through their justice systems. These systems have also advanced access to justice for Indigenous peoples. They resolve disputes, restore harmony, and protect rights in ways that are culturally resonant, responsive, accessible, and effective. Studies show that there is less crime, more durable conflict resolution, and greater biodiversity on the lands where Indigenous law is freely applied. Indigenous peoples' justice systems are inextricably tied to the self-determination of Indigenous peoples, and thus an element of their identities, continued survival, vitality, and development. The right of Indigenous peoples to self-determination, a right affirmed in the UN Declaration on the Rights of Indigenous Peoples and numerous other sources, includes the right of Indigenous peoples to develop, operate, and preserve independent Indigenous justice systems. Still, the recognition of Indigenous peoples' own justice systems and customary law remains limited, and their status varies greatly across countries and regions. In some states, these systems are not recognized at all. In other places, the ordinary legal system neither recognizes nor prohibits Indigenous peoples' justice systems, leaving some space for their de facto exercise. Still, other countries have officially recognized Indigenous peoples' justice systems, but place restrictions on their jurisdiction, or subordinate them to ordinary courts. For these reasons, my report examines both good practices and remaining challenges to the recognition of Indigenous peoples' justice systems. Some have questioned whether this report falls within my mandate. My response is clear. It does, on two grounds. First, my mandate requires me to record and respond to attacks against judges, lawyers, and other justice operators. Indigenous justice operators are under attack in many parts of the world because their justice systems are not accorded recognition and resources. Second, my mandate requires me to recommend ways to improve judicial systems. All judicial systems need improvement, and they can do better in ensuring access to justice for all. This requires recognizing and engaging with Indigenous justice systems where they exist, to ensure the right to access justice for all. This recognition will also translate into improvements in ordinary justice systems, which will better understand how to interact with Indigenous justice systems once they have a clearly recognized place in the national justice system. This report builds on the recommendations made by my predecessors and draws upon the earlier work of the Special Rapporteur on the Rights of Indigenous Peoples, the Expert Mechanism on the Rights of Indigenous Peoples, and various UN treaty bodies and other international authorities and experts. I want to underline that I'm deeply indebted to the input and writings of Indigenous judges, scholars, and leaders, including many whom I consulted in preparing the report. In closing, I reaffirm my commitment as Special Rapporteur to defending the independence of all justice actors, including those within Indigenous systems. President, Chair, Excellencies, honorable participants, let me tell you a bit about communications that I have sent to states. According to international standards, states must ensure that independent judges and lawyers are able to carry out their work without any restriction, improper influence, inducement, pressure, threats, or interferences, whether direct or indirect, from any quarter for any reason. I've raised concerns with a range of states regarding violations of these principles. I will give some examples, but these are by no means exhaustive. In Eswatini, no meaningful progress has been made in the investigation into the brutal killing of lawyer Tulani Maseko, which has had a chilling effect on the legal profession as a whole. In Haiti, I deplore the killing of Judge Maxime Castel and the reports of numerous summary executions carried out by a member of the prosecution service. These acts must be investigated, and those responsible must be brought to justice. This year's Day of the Endangered Lawyer focused on Belarus, where lawyers face repression, disbarment, imprisonment, or exile. The emblematic case of Maxim Snak, sentenced to 10 years imprisonment in a trial behind closed doors for representing opposition figures, illustrates the extreme risks faced by lawyers in Belarus. Snak has been held in incommunicado detention since February 2023. This torturous treatment must end, and he must be provided with access to lawyers, independent medical personnel, and contact with his family. Judges also face persecution. In Ethiopia, 35 judges and 14 public prosecutors were arbitrarily arrested and detained by the police in late 2024. I retained several minutes to further address communications I've sent to governments this year, and I look forward to this interactive dialogue.